Supreme Court dismisses the plea. Maharashtra government submitted the plea to direct the center to share the raw caste census data of 2011. But today, Supreme Court refused to provide this, and Supreme Court uh, given an order. What Supreme Court says, it dismisses the writ petition filed by state government seeking the union collected socio-economic data. The state government sought to be raw census data implementation and reservation for other backward classes, OBC, in the local body election. A bench, the Justice A.M. Khanvilkar and City Ravi Kumar dismisses that writ petition, taking the note of that the stand of union government that Section C 2011 was not exercised to enumerate the data on the backward class and the caste data collected during Section C 2011 was not accurate and thought to be with error. The union government also submitted that there was the data census exercise undertaken under the Census Act 1948 and was done on the basis of executive instruction concerned by Ministry of Enumerate Caste status and the household for the delivery target benefits. In the backdrop, the bench observed that there is an cannot the issue the direction to the union government. It means the central government to share the raw caste data of the 2011 with the state of Maharashtra. The facts remain that affidavit filed before the court by Union of India, it is central government of India, emphatically state that the data which is collected is not accurate and not usable. If that is a stand taken by respondent, we fail to understand how mandates can be issued in the respondent to permit the state of Maharashtra to use the data for any purpose. Such as the direction will lead to the confusion, uncertainty, and we therefore decline the entertainment with the writ petition. The bench noted in their order. Also, there are too many different points in that process. One is the bench also stated that the fact that the state of Maharashtra is obliged to comply that triple test requirement before the enforcing that reservation of OBC in the local bodies. That means the union government can be directed to share the information which they themselves have the classified unusable. It means the bench has, however, given the liberty to the state of Maharashtra to pursue the other remedies available for the law on for the relief. The bench also look the note of that the Maharashtra had constitute a commission for collecting the caste data in the purpose of reservation in local bodies. It means now it goes long and it shows it. They have another options to collect the data, empirical data, and then more. Solicitor General of India Tushar Mehta in the case that Union of India submitted that this raw census data of Section 11 2011 cannot be shared was fraud inherent effort. Now question is that if they are talking about inherent efforts made by the Supreme Court, the central government, question is the census of 2011 have errors? This one, the lead question in that also. Also, the Tushar Mehta, the Solicitor General, also quote that it argued, it's not quote, it argued that for the purpose of reservation in local bodies, political backwardness is the key factor in assent rate. So, 2011 did not have any parameters on political backwardness, and such exercise has to be done in local body. He also highlighted that it is comprehensive data has taken to be in political backwardness, and the date collected to decade cannot be used in any case. In Solicitor General submitted one of quote is that the 11 data is useless and cannot be help you. This is the Article 32 plea by the state of anyway not maintained as they cannot claim fundamental rights. Please don't order us to finish raw data to the state. We have not even furnished to be the public. It is worthless. This is the submission by Solicitor General Tushar Mehta. Now, Advocate Shekhar Nafade is appearing for the state of Maharashtra. He referred the Article 243D, the Constitution of India, the constitutional mandate to provide reservation, scheduled castes and scheduled tribes in local body in proportion of population. The senior counsel also referred to article that 243D, section 6, which enables the state legislator to provide the reservation from backward classes in local bodies, and even relying on this provision, he advanced the proposition of central government has legal obligation under the Census Data Act do not cast immuration to the census so as implementation of reservation in local bodies. Further also disputed the claim that center have that the raw data section 2011 is census 2011 is full of data. They cannot be judged in their own cause of saying the data is of full errors. There is no examination by the independent committee of expert argues. So these are the submission by Solicitor General and the lawyer, the counsel who appears for state government. Now bench at the point of time of sort of known was the legal basis of 2011. Now three questions are there. If the government, if the central government telling that the data have errors, so is the data, the census 2011 have accepted with errors? This is one question. Second question is about the state government. If this empirical data is very important for all of us, for all of the state government, then why the state government is not indulged in to collecting the data? This is one the lead question. Third is now what are the consequences in that? Local body elections are going on. The Mumbai elections are Mumbai election is on way. So what impact on these elections? It is more importantly need to take a look. We talk today. We have discussion now. Some of OBC leader will also in contact. So we'll talk them and what exact now in the future we'll take a look. For right now it is okay. Thank you.